Now we have Professor Dr. Sandipa Bhat for the keynote speech. He's working as a professor of law and director of Center for Aviation and Space Laws at National University of Juridical Sciences, Kolkata. Dr. Bhatt has published more than 45 articles in the journals of international and national repute. He has presented more than 90 research papers in international and national conferences. Sir, please.
Yeah, thank you. I think first of all, actually, you have got a quite old photograph of mine in the university website. Maybe it's 15 years back, maybe more than, or a little more than that. Okay, right.
They want to keep you young always.
Okay. Yeah, I'm young still by heart, so I should actually acknowledge it. Right. So, good morning to all of you. And I should also say good afternoon and good evening to some of my friends, the resource persons who have joined from other parts of the world as well. I should thank them first for actually honoring my invitation and being part of this conference. So thank you so much for all the resource persons who have joined from different parts of the world. I am also having the privilege of sharing this inaugural session with Professor Ricky Lee, one of the eminent figures, eminent personalities in the field of space law. Coming to my topic, since actually today's discussion is on the privatization of the space sector in India, I thought of speaking on whether we are legally ready for the privatization of the Indian space sector. So how far we are ready for that? As a backdrop, let me tell you that the Indian space sector has been predominantly a state-oriented space sector. Over the last more than, say, 4 to 5 decades, it has been the Indian Space Research Organization, which was the sole player in terms of the space activities. It was nothing but actually the government-run space activities. There was no scope for the privatization. Of course, an attempt was made in 1992 by establishing a body called as Antrix Corporation. Of course, it's a very limited attempt. I'm not saying that actually it's a full-fledged effort for the purpose of privatization of all space activities in India. It is just to commercialize the ISRO's space application. So a kind of a commercial arm was basically established in the form of Antrix Corporation. To a limited extent, Antrix Corporation has been successful. Some private companies have started up. Of course, they are also involved only in some peripheral space activities, not the direct space activities like launching or maybe controlling directly. All those kind of activities have not predominantly started in India. As all of us know, during COVID-19, almost all the parts of the world have been heavily affected in terms of their economy. India is one of those countries, of course, has been affected enormously in terms of the economic problems. And there have been plans for the purpose of coming out of the economic problems and to boost the Indian economy. One of the plans which has been put forward by the Prime Minister has been to go for the privatization of the Indian space sector. When we mean privatization at present, it is not just commercializing the ISRO's space applications, but also to go for even the private players to establish the launch facilities, carrying on the launch operations, and also even actually receiving the signals and so on and so forth. So all kinds of the space activities are contemplated under the current plan. And already proposal has been made and even the draft has been prepared for the purpose of establishing the IN space, that is the Indian National Space Promotion and Authorization Center. Right, so there is a center which is going to be established for the purpose of permitting and overseeing the private space activities in India. And this proposal includes multiple aspects like the sharing of the facilities, whatever ISRO facilities are there for the purpose of launching or any other kind of the space related applications, they would be shared with the private players. There would also be possibility of establishing the new facilities by the private players in the Department of Space premises. They can also go ahead with the establishment of their own launch facilities. There would also be provisions for monitoring the space activities by the private players. And even there is also another link in terms of the ISRO industry interface. That's primarily to, again, continue with the commercialization of ISRO's application. So ISRO would be willing to help the private players, if at all they are intending to take the services from the Aero for carrying on their space activities. So these are the major plans which have been done at present for the purpose of the privatization of the space activity. Now, does this mean that India is going to become a safe haven for the private space players? Is it that we'll be having more and more private space activities in the course of time, especially because maybe the cost of launching and operation in India is comparatively less when compared to that of most of the countries? So precisely because of that reason, is it that India is going to become a hub of the private space players? I should say, hold on. Hold on. Where is the law? Where is the law for the regulation? We have already committed in the international level in different space treaties certain kind of actually the obligations. We are parties to the Outer Space Treaty, Rescue Agreement, Liability Convention, and also Registration Convention. Though we have signed the Moon Agreement, we did not actually ratify that. So out of the 5 major treaties governing the space activities in the international level, we are parties to the 4 major treaties. There are obligations under the treaties which we need to implement. We cannot bypass those obligations while carrying on while authorizing the private space activities. So we have to be permitting the private space activities within the 4 corners of the obligations, whatever we have undertaken under the international space treaties. Now, what are those key obligations which require supplementing in the municipal level so that the private space activities can be properly regulated? Let me highlight upon these key issues. I'm not saying that these are the only issues. What I'm saying is that these are the major issues which require the proper regulation before we start the private space activities. First is the question on responsibility and liability. If we look into the space treaties, Outer Space Treaty has a provision under Article 6, which says that appropriate state party to the treaty shall be responsible for every space activity, whether it is carried on by the public entity or by the private players. So for all of them, the state is responsible, the state is responsible. And there is also a requirement of authorization and continued supervision of the space activities by the concerned state. Then as far as the liability is concerned, we have Article 7 of the Outer Space Treaty, which has been supplemented by the Liability Convention 1972. That's a separate convention also in terms of the liability for the damage caused by the space activities. Interestingly, both the Outer Space Treaty and the Liability Convention speak about the liability of the launching states. They don't mention about the liability of the private players anyway. Of course, it's understandable because it was 1960s and 1970s. During that particular period of time, only the states were the primary players in the space activities. Therefore, these laws or these international treaties are entered in light of regulating the state-oriented space activities, not the private sector-oriented space activities. Right? So, therefore, it speaks only about the liability of launching states. And the definition of the launching state is wide enough to encompass any launch, whether it is by the state or by the private player. Because you have, say, a state which actually launches the satellite, state which procures the launching of the satellite, state whose territory has been used, and state whose facility has been used. All 4 different categories of the states do come within the ambit of the definition of launching state. And all of them are jointly and severally liable. In case of any damage, they're jointly and severally liable. So even if a private player is launching from India, at least by virtue of allowing its facility or the territory for the purpose of the launch, it would come within the ambit of the definition of launching state. So in both in terms of responsibility and liability, we can find that the state would come into the picture and there is no mention about the private players as such. So that is why we have to find out, suppose if the private players are going to carry on activities extensively in India, what should be the extent of responsibility for India as a state? What should be the liability for any damage caused by the space activities by all these private players? All these things need to be properly assessed, and we have to make proper arrangement for the purpose of ensuring that there is some kind of cushioning of the liability, either by the private players or through the insurance mechanism. If we look into the other countries' models, they've already come up with maybe some of them in terms of the liability sharing arrangement, and almost all of them in terms of a compulsory space insurance. They will insist for actually insurance coverage. So in case of any damage caused by the space activities, insurance companies will be coming for the purpose of payment of compensation. So that's how they have worked out the liability sharing as well as the space insurance in most of the countries. But in India, we might have to think a little more reflectively, because liability sharing and space insurance, both of them might have their own limitations. Liability sharing, how much of the liability a developing state like India can share with the private players, that's really debatable. How much can be cushioned by the state is really debatable. Space insurance, in a circumstance wherein the insurance company becomes bankrupt by catastrophic damage, then the liability under the liability convention would still exist. The victim state would claim compensation under the liability convention, and India as a state would be liable to pay compensation. As a launching state, it would be liable to pay the compensation. So therefore, even the space insurance might not work effectively in a country like India. So what I propose is that we have to think in terms of establishing a space fund, maybe through the contribution by like the private players or maybe the public entity, whatsoever it may be. All of them may contribute a certain percentage of the profit, whatever they have made, to create this space fund, which would help in terms of actually paying the compensation in case of any damage being caused out of the space activities. And this has been effectively worked out in the nuclear liability regime. We can find that many countries have already created a civil nuclear liability fund. So similar kind of a mechanism might be required in India to deal with the aspect of the liability. Second major issue is in terms of the property right. If we look into Article 2 of the Outer Space Treaty, it clearly says that outer space, including the moon and other celestial bodies, is not subject to the national appropriation by claim of sovereignty, use or occupation, or by any other means. And it reflects the sentiment of the common rights regime, whatever has been advocated by the drafters of the space treaties. If we go back to the 20th century development in terms of the space treaties, they have advocated for the common rights of everyone. Even though Article 2 speaks about national appropriation, it in turn also prohibits the individual appropriation. Private players also cannot actually claim property rights. It is absurd to argue that the states cannot claim any rights over the outer space and celestial bodies, but private players can claim the rights. So it's an absurd argument. And unfortunately, there are many people who are already claiming certain rights over the outer space and celestial bodies. We have people like Dennis Hope, Sylvia Langevin, who have all actually claimed the different celestial bodies. So in order to ensure that such a kind of activity would not happen in India, we have to have the proper clause or proper regulation in the national space legislation. We should not allow such kind of things, because allowing such a kind of a business or such a kind of an activity would be contrary to that of Article 6 of the Outer Space Treaty, and India as a state would also incur responsibility for the failure to regulate these kind of activities. Next, third aspect, I should say we need to regulate space tourism. Space tourism is going to be in all probability, the next generation fascination. Already, many private players have developed their technology, so they are about to actually launch, they are about to actually start this business of the space tourism. It might enter into the Indian sphere, especially because of, as I have already pointed out, the cost effectiveness. So primarily because of that reason, we might have actually the extensive space tourism activities. Operators may start carrying on the activities from India. But this also poses multiple questions. Questions with respect to activities of the tourists in the outer space. If they commit a wrong, if they commit a crime in the outer space, how to exercise the jurisdiction over them? What kind of law should be made applicable? Then, in case of an emergency landing of the space tourist, what are the obligations of the other states wherever the emergency landing happens? Even though we have a rescue agreement of 1968, the rescue agreement speaks about only astronauts and personnel. It speaks about the protection and the return of the astronauts and the personnel. It doesn't mention about the protection of the tourist person. So the question is, whether the space tourists do come within the ambit of the definition of astronauts and the personnel, are they entitled to protection under the rescue agreement? I believe no, they would not be coming exactly under the protection, because the rescue agreement is a logical extension of Article 5 of the Outer Space Treaty, which says that the astronauts are the envoys of the mankind. They are the representatives of the mankind, especially because they'll be carrying on certain activities in outer space for the benefit of the mankind. But space tourists are not going for that. They're going for their personal enjoyment. Applicability to the rescue agreement is also debatable. So, in order to properly regulate, and even another important problem in terms of space tourism is that who is going to authorize and who is going to continuously supervise the space tourist activities? Is it India, because operation is taking place in India? Is it some other country to which the operator belongs? Is it any other country to which the space tourists belong? So, which country would be actually having the duty to authorize and continuously supervise the space tourism activities is something which is really debatable. Therefore, it need to be clarified in the Indian regulation. Next aspect is the protection of space environment. Outer space environment is very fragile. And if you look into the current statistics, the picture, or maybe actually the existence of the debris in the low Earth orbit and in the medium Earth orbit brings in a kind of a very, very scary scenario. There are a lot of debris in the lower Earth as well as the medium Earth orbit. This debris would be a major threat for even carrying on our future space activities, because they move with a very, very high velocity, and any object which would come in the way of the space debris would be destroyed completely by the debris. So, precisely because of that reason, we have to cater to the space environment while carrying on the space activities. And it has to be carried on in a sustained way. We have a provision under Article 9 of the Outer Space Treaty, which says that while carrying on activities, there shall not be any harmful contamination of the outer space and adverse changes in the Earth environment. That's what it basically speaks of. And it also says that states need to take appropriate measures for the purpose of ensuring that any actor, maybe the state actor or the private players, would not be harmfully contaminating outer space. So that has to be implemented in the municipal level by categorically mentioning in the national legislation. Significant aspect is about the military activities. Space activities started in 1957, primarily for the purpose of taking military advantage. Whatever may be the argument which has been put forward, both US and USSR were interested in using the space technology for the military purposes, because that was the time of the Cold War, right? Cold War era, and they wanted to outweigh each other in every sector and wanted to have some military advantage. And it was understood by the international community. You can see that in the series of UN General Assembly resolutions, as well as subsequently in the Outer Space Treaty, there has been a mention about the requirement of peaceful users of outer space and celestial bodies. Article 4 of the Outer Space Treaty primarily speaks about it. Of course, there are many loopholes in Article 4. I'm not going to discuss that because this is not the platform to discuss on Article 4 of the Outer Space Treaty. What I can tell you is that Article 4, to a limited extent, speaks about the de-weaponization and demilitarization of the outer space and celestial bodies. Right? So it speaks about that. But as I told, space treaties obligations are mentioned only on the states. And whenever the state is authorizing the private players to carry on the space activities, it should ensure that even the private players are not going to violate these provisions. So militarization by the private players should be prevented, and it should be ensured that outer space could be used for the beneficial, peaceful users rather than the military activities, which might result in hostility and ultimately threaten the international peace and security itself. Next aspect is about the IP issues. All of you must be aware of the fact that there are inventions which are going on in the outer space. International Space Station project, or maybe other kind of the stations, the proposal for them, all of them are primarily for the purpose of carrying on inventions in outer space. This is because outer space atmosphere is conducive for carrying on certain kind of inventions, especially near zero gravity available in the outer space. That would be useful for pharmaceutical inventions. Different kind of the pharmaceutical products can be actually invented because there will be greater purity in terms of the compounds which may be created. So that's why inventions are going to take place extensively in the outer space or maybe in the celestial bodies in the future. Questions which would crop up regarding these inventions would be, can there be patent rights to be granted? Patenting. Why am I saying this? I'm saying this because the patent law is primarily dependent on the monopoly right logic, but whereas the space law, as I've already pointed out, is advocated on the basis of the common rights principles. Monopoly rights versus the common rights. So you use actually certain things in the outer space or maybe in the celestial bodies, you produce something, can you get a monopoly right on the product? Especially if you go for a product patent. So can you get a monopoly right on that? You use the common resource for the purpose of actually creating this. So therefore, there are debates about the conferment of the patent rights, especially in terms of the product patents. There are also problems in the circumstances wherein an earthly patent has been infringed in the outer space. So what law has to be made applicable? We don't have the international patent law. So what law has to be made applicable and who has the jurisdiction? All these issues are debatable regarding the IP laws. Finally, I should say about the financing of the private space activity. Whenever we speak about the private space activity, unless and until there is a financing, it is not going to kickstart. Space activities would involve multi-billion dollars investment. That would be huge investment. You need finances from different jurisdictions. Single jurisdiction finances might not be able to support you to the extent of multi-billion dollars. Unless and until every creditor is ensured of the fact that they will get back their investment from the debtor, nobody is going to invest in the sector. Right? Nobody is going to invest in the sector. So they have to be confident about the return of their investment. And our municipal laws are varied in different jurisdictions. Consequently, there will be a lot of confusion and chaos which will be created out of it. We need harmonization. In fact, Unidruva has tried to harmonize the private laws on the financing sector. They basically looked into the mobile equipments, which also includes the space asset. So they have come up with a convention and also a draft space protocol. Unfortunately, that has not been actually entered into force. The system has not entered into force. It has also been rejected by the financiers to a greater extent. So precisely because of that reason, we have to cater to this in the municipal level so that we will ensure that sufficient investments will take place in the private space activities. So therefore, in my concluding remark, I should tell you that the privatization may be essential. I'm not against the privatization, right? So all these things are not supposed to be construed as I'm opposing the privatization. Privatization may be essential for the purpose of boosting our economy, but we should ensure that we are also going to respect our international commitments under the space treaties. We are not actually commercializing by compromising our obligations under the international space treaties. And for this purpose, the law should precede the practical aspect of commercialization. Right? If we go for commercialization now and think in terms of the development of law subsequently, it is going to be a futile exercise. It is not possible to regulate it properly. And I should also say before concluding that India is law. Since 2001, there have been actually multiple attempts which have been made. And in 2017, there was also a draft space legislation which has been prepared and open for the public comment. However, there are a lot of loopholes. There are a lot of loopholes in the draft space bill. I think there are some presentations which are going to be done on the draft space bill also in today's session. So let me not delve into it in detail right now. Let me tell you in my final observation that we should have the law first, and then only we should go ahead with the privatization of the space activities. That's all. Thank you.
Thank you so much, sir.